We called this topic Stranger in a Strange Land because my practice over the last 35 years or so has been entirely medical malpractice. And you could count literally on one hand probably the number of cases I've had that ended up in federal court. In terms of the experience we had in this recent case, along with my partner Patricia Giordano, I thought that there were a few pearls that we wanted to share with you. I'd like to start just by giving you some background of how the case got into federal court, because as I said, that was a little bit different. The case appeared to be, if there's any such thing as a garden variety obstetric disaster, a garden variety in the respect that it raised the classic sort of cases about fetal monitoring, the obstetric care, there was a nurse midwife, there appeared to be communication problems that had led to the delivery of a very, very depressed little girl. And the next thing that happened was we got removed to federal court. And there was a motion to dismiss on the basis that the obstetrician, as it turned out, was a deemed federal employee through a plan to provide, as it turned out, really incompetent obstetric care to individuals who lived in underserved areas, AKA poor areas, of the city of Philadelphia.
If you know that you have a claim against a federal employee, you must first give notice to the agency that employs that person. You can do that by using the standard form 95, which is found on the Department of Justice website. It is a very simple form to fill out, and sometimes your clients are going to have filled these out before they come to you. But there are some pitfalls you need to be aware of. One is you need to realize that you need to file a separate claim for each claimant. You don't need to file a separate form, but you need to list each claimant. But perhaps the most litigation has come over this demand for a sum certain. And that is a monetary demand. You cannot say in excess of the arbitration limits. You can't say to be provided. You can't say anything that is not a monetary figure. And if you fail to say a sum certain, that will be fatal to your claim and you can be tossed out of court. That's your ceiling. That's the most you can recover. So you want to be obviously very generous if you are filing that. So now we're in federal court, our case gets dismissed. What do? Within 60 days of that dismissal, without prejudice, obviously, you need to serve that standard form 95. The agency then has 6 months to review that claim. This is the part where they're supposed to facilitate prompt settlements. I don't know anyone who's ever had a decision made in those 6 months, because the flip side is if they don't make a decision in 6 months, it is a deemed denial. And once you pass that 6-month mark, you then have 60 days to file your federal complaint. So you need to follow those time frames very carefully.
Well, there are substantial differences between the state practice and the federal court. There are substantive differences in terms of damages and interest available. No punitive damages, no prejudgment interest as to that defendant. The attorney's fees are also limited. The federal courts of civil procedure, of course, apply, and that's different than our rules of procedure in Pennsylvania. There are a whole slew of preliminary mandatory disclosures that must be made, and then there are discovery limitations. And then, unlike state practice, there are expert depositions. The case would also have presented enormous challenges if we ultimately took it to trial, because the U.S. is entitled to a bench trial, a non-jury trial. And then we have all these other defendants who have demanded and are entitled to a jury trial. Counsel for the private defendants and I said, look, obviously this is not working. We were heading towards a pretrial conference. Why don't we just take this out of the federal court system and just hire a good private mediator? This was something that the U.S. Attorney's Office was very reluctant to do. Ultimately, we did get an agreement to go to a private mediation. We'd started suit fairly early in this little girl's life, and so we'd had some time to see how she was progressing. And unfortunately, she really was doing quite poorly, much worse than one would have hoped. And she developed very, very severe respiratory problems. So one of the things that Trish and I talked about was whether or not we could amend our Form 95, which at the time had seemed like a generous amount.
So let's go back now to talk a little bit about this motion to increase the administrative claim. The law says very clearly that you are allowed to do it if there is newly discovered evidence not reasonably discoverable at the time the administrative claim was filed, or a change in facts relating to the amount of the claim. But the government, of course, wants to come in and say, no, 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 the law does not allow you to do this. You have an obligation at the time you file that claim to anticipate the worst case scenario. And you are only able to increase that amount of your claim for injuries that were incapable of being diagnosed. That's not what the law says. So you need to be careful that the government, if they're going to oppose this, isn't inserting law that just isn't there in opposition. But the bottom line is our motion was granted.
The U.S. insisted upon placing a substantial portion of any settlement proceeds into what's called a reversionary trust. It's your worst nightmare. 90% of the way through the case, they said, we're going to do this. And what it involves is an ongoing relationship between the patient client and the United States government as to the provision of health care. The fact that it's done that way makes the individual ineligible for other public resources that they rely upon. The way that the case went down, we finally went to a private mediator. We were able to get the case settled with the non-U.S. defendants. That substantially cranked up the heat on the U.S., and the U.S. ultimately capitulated and agreed not to put any of the money into a reversionary trust. And the case was settled for a total of $16 million. Thank you.